Okay. First of all, I'd like to say that I've been working on the issue of employing fair use for different creative communities for the last 15 years. I've always worked with a really wonderful group of lawyers. I'm not a lawyer. Therefore, all the information I'm giving you today is information that I'm very confident about the validity of, not because I'm a lawyer, but because it is already very well established both in law and practice. There are many, many parts of copyright law I don't know much about. Thank God Jenny and other people on this call are here for that. But what I want to talk to you about today is specifically parts of existing codes of best practices in fair use that exist that can help archivists in doing their daily work. So what I want to do is breeze through these points, make a point to you which I think is probably not necessary, about why fair use is important in archiving, go through the baby steps on fair use, talk about how codes of best practices work, and then give you a few more resources. So these are areas in which people routinely need to employ fair use. When they collect materials, often you have to make a preservation copy, and right immediately you face a fair use question about, is it possible to copy something, since copying it in its entirety is an infringement unless it's fair use. Making it accessible to other people, particularly to patrons, but also to your colleagues in other archives. Exhibiting it in some way, whether digitally or on site somewhere. Curating it, combining your materials, and putting them together in new ways, which might be considered a fair use, and then sharing it more widely. When this happens, people typically, when they run into copyright issues, when they have to do these things, they typically look some version of this. And when they have faced that level of uncertainty, what often happens is this, which is around 1/3 of those people decide to send their work to the trash can. They decide to either not do something, or to steer around it, or even to not consider it at all. They may not even be aware that they are rejecting the possibility of doing something, because they are so thoroughly decided that you just can't do something like that without encountering copyright problems. That is a form of self-censorship. The reason why it's important to understand that as self-censorship is it deals directly with the nature of copyright under the Constitution, which is where I'm going to take you with understanding what fair use is. So in order to understand fair use, we have to walk all the way back to the Constitution and ask ourselves, well, what is the purpose of copyright? Now, if you ask your colleagues what the purpose of copyright is, they are likely to tell you that the purpose of copyright is to protect the interest of the copyright holder, and that's the function of it. However, that's not the function of it in copyright law. It's not the function of it in the Constitution. The function of copyright in the Constitution, which is a document written by people who hated monopolies, and it's a monopoly. The reason you've got a little monopoly in there is that the people who wrote the Constitution, again, anti-monopolists from the get-go, that's why they decided to separate from Britain, is that they thought that if you had a little smidge of copyright in this brand new country that was rather unprepossessing, in fact, kind of had previously been the butt end of empire, let's be frank. If you had a little bit of copyright, you could convince people to write books in America rather than in England. So they created a copyright that would apply to books. But the way that they wrote that monopoly was to say, the reason we are having this monopoly at all is because we think that we need protection in order to promote the creation of culture. Now, the Constitution is very clear. There are two general buckets of ways you do that. You can reward creators by giving them limited monopoly, which we do, and the Constitution is very clear it has to be limited. And second, we can encourage new makers to use existing culture that is already copyrighted. Now, this was not an important issue at all when the creator of the Constitution wrote the Constitution. It did not become important at all for at least 150 years. When it became really important was 1976, when we wrote a very fundamental change to copyright law, which made it very, very long, very strong. At this point, the biggest balancing feature that provides a limitation to copyright is fair use, which is a very general and flexible term saying your use of copyrighted material is not infringing, and your unauthorized use of it is not infringing under some circumstances. And so now you all know what fair use is, and we can go home, right? No, because we have these three little words, under some circumstances. So the law incorporates some case law saying that there are 4 things you should consider. These are often known as the 4 factors. They're regarded with some reverence, especially by non-lawyers. Lawyers do not regard them with any reverence at all because they see the way that they do not allow you to determine much of anything because they can be weighted in different ways and have been interpreted differently over time. But these are the 4 factors. That's the last time I'm going to talk about them today because I want to talk about what happened to the 4 factors. What's going on right now is that judges have, since 1990, come to a very, very stable understanding of fair use. They have done so partly because of a legal article in a law journal written by a judge, Pierre Laval, that was written in 1990 and then put into case law immediately and went to the Supreme Court. This describes the necessity of a balance of interests in copyright, and particularly the importance of fair use. Since that article was written, the Supreme Court has come out with 2 different cases explicitly saying that fair use is basically what permits copyright to be constitutional. Now, let me just walk you back. The Constitution says we allow this little copyright monopoly. It also says there's a First Amendment, and the government cannot create laws that create censorship. Now, if you permit somebody else to censor because you've created a law that lets them censor, that is an infringement of the First Amendment. So without fair use, without the rigorous use of fair use, at this point, copyright would become unconstitutional. And so judges have become extremely friendly to fair use. Judges currently ask 2 questions that actually make sense of those crazy 4 factors. What they have come to ask is your use for some new transformative purpose? And they do not mean transformative in the sense of I made it purple. What they mean is, did you employ it for a new context? For instance, archiving. Second, have you used the appropriate amount for that transformative purpose? As you probably have noticed, in archiving, sometimes that appropriate amount is 100%. And there are court cases that have said 100% is fine if that's the appropriate amount for the transformative purpose. In practice, although not in law, what judges also consider is what do creative communities do? It's especially helpful when it's well documented. There was a court case that just happened involving the visual arts where one of our best practices codes was just put into the court record. So the question is, if judges love this stuff, if fair use is central to the constitutionality of fair use of copyright law, why don't we employ copyright law more fully? Here are the 3 most popular reasons that people tell us, which is that they are afraid to get them or their organization in legal trouble, they're afraid of losing relationships, and they're afraid of bad publicity. This central one, the lost relationships, is in practice overwhelmingly what people are really worried about. Legal trouble almost never happens. Here's what is really important for anybody who works in an institution to consider. That yes, life is risky, and yes, using your rights is risky. But you have to consider risk in context, and you have to understand what the level of the risk is. There is legal risk associated with pursuing your mission in a lot of ways. In many ways, you operate an archive, somebody can walk in and slip and fall, and that's a risk. There are plenty of risks, but you have to know what the actual risk is that you're trying to assess. And then you have to also assess the risk associated with failing to get your mission done. If you are going to avoid risk so completely that you don't do any work, you've now succeeded in being extremely safe but not having a job. So this is where best practices codes come in, because they help people understand what is normal in their field. Librarians have established a fair use code that is extremely useful to every kind of archivist. And here I've cleverly forgotten the name of the person who is working in the university. Is that Dave? I hope so.
Yes, that's me.
Yes, thank you. So Dave, this is going to be super, super important for you, but it's also super helpful for lots of people working in a variety of archiving, because academic librarians have to face fair use issues for their patrons all the time. Here's some of the areas of advice that exist in this code. This code has 8 different features in it. 5 of them are directly appropriate to anybody in archiving. First of all, what do you do about copyrighted material that shows up in exhibitions? And also promotion, and also producing promotional material, brochures, and so on. What do you do about digitizing your work in order to preserve it? What do you do about creating special collections? What do you do when you are saving items with third-party material that is copyrighted? And what do you do about collecting evanescent material, for instance, World Wide Web material or social media, in which case this stuff often has no authorship at all. It's probably all orphan work stuff, a lot of it anyway. Another code that's very helpful to you, and I'm going to go to the codes after I finish this PowerPoint and walk you around the site a little bit, is a code we recently did with these adorable people who are software preservationists. Those are the people who are unlocking data that was locked up into VisiCalc before VisiCalc was superseded by Excel, who are able to access the previously inaccessible versions of CAD software for architects, and people who will let you be able to read a document in WordPerfect. These people are really, really hamstrung without fair use. Everything they work with is recently copyrighted. We also did a document that I think is going to be supremely important for any memory institution, which is a document that the Sloan Foundation asked us to put together, working with a variety of memory institutions and archives on how to consider fair use for orphan works. This is of great interest beyond orphan works, because in practice, fair use applies to orphan works just like it applies to everything else. So basically, this is a statement of best practices in fair use for archives. In this document, there is explicit direction to you on preservation, on accessing material, that is to say your patrons accessing of it, on fair use issues around curation, how to write better donor agreements so that fair use can be used, because donor agreements can override fair use, and how to communicate with the public to make sure that you get the feedback you want in case anything on your site is something that somebody really minds having there and they didn't even know it was there. Another document that I think will be very interesting for especially archivists in the arts is the dance archivists. Dance archivists wanted a fair use code because dance is an extremely evanescent art form, and it's very, very hard to describe in words. And it's very important for people to be able to see what a dance looks like. And yet dance records are often produced on our outdated materials. They're archived in some backwater place that people can't get to. Dance archivists are often ex-dancers themselves and feel very powerfully that the art form needs to be maintained into a next generation. Their code I think will be very useful. There's a lot of other codes too. I'm going to show you a site for how to access them, but I've selected the ones that I think are more meaningful to you. I'd like to just point out that in related fields, the use of such codes has actually resulted in true and sometimes dramatic industry change. The biggest and most obvious change that I can point to is when documentary filmmakers got a code. Insurers of errors and omissions within 6 months began to change their practices. Within a year, every errors and omissions insurer in the United States had moved 180 from, well, we never really clear for fair use, that's a carve out, to, of course, be clear for fair use under the terms of your code. We have really great example of university archives where collections were digitized quite successfully and they're made available to the general public. We have examples of art scholars who were able to publish their work in journals that had never accepted an unpermissioned illustration before. And we have examples of museums being able to conduct online visits. This is one of them, and I'm going to show you it in real time in a minute. A couple things to remember about codes of best practices is that they are not rules. And in fact, any rule that anybody ever told you about fair use is wrong. That is to say, if anybody gave you a number, they said 20 seconds, they said 30 seconds, they said 400 words, they said change it 7 times, none of this, it's all folklore and it's all not true. Fair use is about reasoning, which is why it's important to understand what the reasoning is. And the codes give you an introduction to the reasoning and then give you the specific circumstances, for instance, for archiving, where the reasoning would apply, and show you how your peers at a field-wide level have thought to put limits on it. Fair use is always dependent on the context. That's why it is sometimes difficult for your general counsel at a university to, who probably isn't trained in copyright law, to think through what it means to try to use existing fair use rules of thumb for a pandemic. These codes are based on professional consensus, not on law. Lawyers do take a look at them and approve them and tweak them until they're thoroughly sure that there are no problems with them, but the consensus is on the part of the people in the profession, and that's what's really important about them. There's never any negotiation with people who are not in the profession, because those are not people who have an investment in getting the job done and getting the mission done. One thing we've learned is that practice makes practice. In other words, the more you do it, the easier it is to do. I'm going to show you some of these resources. This is the book that my colleague and I, Peter Yassi, who is a lawyer, wrote, which provides some greater background for you. You have no trouble sharing this presentation with anybody you want to, and if you want to excerpt it, there's always fair use available to you. This is my email, but of course you have it on Basecamp as well. And now we're going to go to your issues. Before we do that, I just want to go to the site so that we can see. Come on, there we go. This is the Jacob's Pillow website, digital exhibition I was showing you. You can select by era, by genre, by artist, and by playlist. We can go to a 1937 performance by somebody I've never heard of. Ted Sean's Men Dancers. They're dancing something called Kinetic Mole Pie, or they will as soon as it loads. While it's loading, let me show you that on the right, Jacob's Pillow, an dance archive in upstate New York, has produced a short version with links of both what was happening in and also in what way it participated in an era. I'm going to stop it, but this site conforms to the expectations of dance archivists for a fair use of copyrighted material in a variety of ways. I actually shouldn't have shown you one from 1937. I don't even know if that's still copyrighted, but let's presume I'd shown you one from the 1980s. They have selected an appropriate amount. They've selected enough of this dance form so that you can see what the choreography looks like and would be able to describe it and understand it. but they haven't shown you the whole dance. They have provided context. They've given you some information about the performers, about the choreographer, and about the era. And they have allowed you, they have clearly identified this as an exhibition site that allows you to browse in different ways. So they're conforming to ways in which the dance archivists thought were appropriate to fair use. They've never gotten any pushback on this. They've just gotten a lot of gratitude. This is the site, cmsimpact.org. It's actually your masking URL is just cmsimpact.org/fair-use. But this is where all the codes live, along with a lot of other material, including some teaching materials, infographics, etc. It just goes on and on. We also have a boatload of fair use videos on our YouTube site under the fair use tab. Here's the document that I think is your mother lode for archives and libraries. One of the nice things about this is that there's ancillary materials as well as the codes themselves. Tell me this is going to work. Yes. Okay, this deep dive is something I hope you never have to read, but it's designed for your general counsel, who is the person who said, no, 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 I run the asylum and you're the inmate. You really don't know what you're talking about. This is where you're like, oh, well, maybe I'm the inmate, but here's some GC level information from real lawyers describing why this approach is legitimate. This is an infographic that I love. We developed it for the software people, but it's on our site for the software preservation code, and it shows the importance of fair use for archivists. And here we have the Library of Congress's digital preservation program, having identified 440 file formats, that there's 83.5 software titles indexed by Wikidata, but only 133 of them are in the public domain. So this is an overwhelmingly copyrighted area. If you're working in AutoCAD, good luck working on anything but the one that just came out, because all previous versions are non-interoperable and they're all copyrighted. Millions of thousands of file formats, description of why fair use works, the factors, what's really important to consider, and then the scenarios for software. There are similar kinds of infographics for other areas as well. Whoops, wrong place. And then here's the librarian's code page. This is my colleague, Peter Yassi, in a really unfortunate moment. He's not happy about that picture, but my GA told me he couldn't get a better one. But these are the different sections. All you have to do is click on them to see where you want to be. You don't care about Juan. All right. And my slides are also up on SlideShare if you don't feel like going to AMIA. And here we are. I'm done sharing my screen, and we're done with the presentation. And William Morrow is coming back in.
Thank you so much, Pat. That was a wild ride. A lot of information packed into a short time. Congrats on putting that together.
As you'll notice, the whole point of this is to stimulate you to actually look at those documents. I don't think having me explain them is at all necessary. You guys are all great readers.
Well, I'm just curious if there's anyone in this group who is comfortable sharing just any issues that you've encountered in your profession and your place of work, or just in general in your life, that interacted with fair use in some way that you would like to see addressed by this committee. No, you're all experts.
So I would like to take the opportunity that seeing Dave has triggered for me. One of the wrinkles for employing fair use is the Digital Millennium Copyright Act, which strategically, of course, does not mention fair use. The Digital Millennium Copyright Act makes decryption of encrypted material illegal, criminalizes it. And if you got an exemption, which most people on this call do have an exemption to break encryption, that encryption is for short clips, not for an entire film. And the university community right now is besieged by people like me who are like, excuse me, the only version of this particular movie that I absolutely have to teach with is in hard copy, and I need you to turn it into a streaming version so that I can teach this class. It is central to my teaching mission. And they're like divided between people who in the library community who are like, yes, but we can't break encryption because of the DMCA, and people who are like, you know what, fair use overrides our concern about that if what you're going to do is have us make this streaming copy, make it available for your students for this limited time, say the 2 weeks that you're going to be teaching about it. You pull it down on off of your site afterwards, and it's completely passworded. Now, obviously, a Blackboard site or a Canvas site is not, it's not lockdown secure. They can share a link with their roommate if they want, but it is reasonably secure. And so my university, I'm very happy to say, has in the occasional situations where they're unable to find another way to meet my need, have been able, and I have 2 such situations, have been able to copy on a temporary basis this film. I'm talking to other colleagues whose library administrations are really believe that DMCA overrides everything. There's a real division, I think, in libraries right now between, given the exigencies of the pandemic, between interpreting, using their traditional ways of interpreting fair use and saying, actually, the pandemic provides a new situation that requires the employment of fair use in order to meet mission minimally. And what we have to do is make sure that we're identifying that mission very clearly, and we stick purely to that mission, and we do everything we can to provide guide rails and security around that. That's where codes are very helpful, by the way, because the codes all have a limitations section to the employment of fair use that provides very concrete ways you can limit things.
I couldn't agree more with that. And you know, we've sort of instituted a similar system here that's sort of in compliance with TEACH as well, sort of the technical standards that are outlined in the TEACH Act, which is an extension of Section 110, which permits in-classroom screenings and things like that. And you know, having things in Canvas where they're only accessible for a short period of time for students who are enrolled in a given course, it's under the discretion of an instructor. The Canvas interface also allows for things like transformative use, like time-stamped tagging and clipping and excerpting, which we feel enhances the fair use argument. But it's the DMCA thing. So that's one thing that I have a question about, because fair use is mentioned in the DMCA. It's in Section C, subsection 1, where essentially it says nothing in this, and I could put the link in the chat.
Oh yeah, right.
Yeah, so it says that nothing in this law, nothing in the DMCA can affect legal arguments like fair use. And I've been hearing forever that fair use isn't necessarily a reason to break encryption, and the courts are split on it. There has to be this nexus of infringement, or some people are saying that there can't be ever any kind of exceptions to it. But like, it says it right there in the statute of the law that the DMCA doesn't affect fair use. So I've always been confused about sort of where that argument comes from, and why folks are saying that fair use and the DMCA are these incompatible things, where, for my interpretation, it says it very explicitly in the language of the law itself that this doesn't affect fair use. Right.
You know, it's the DMCA is it's a real mess of a law, but the functional part of the breaking encryption part has to do with those exceptions, the exemptions they give you every three years, and the exemptions are always very carefully written not to invoke fair use. Um, and I agree with you that you can stand on the, fair use allows you to, especially in a moment of crisis, to do what you have to do. But and again, I'm not the lawyer. Maybe somebody else here knows the answer. But in general, that clause has actually not been usable to work against the anti-circumvention parts of the DMCA. What has been usable is the exemptions, which have worked well for professors, for students, for nonprofit makers, bunch of security people, and are applicable to the kind of work you guys do. But I don't know that that's ever been tested. Does anybody else have a good answer for that? Jenny, do you know?
I don't know.
I can go back to my real lawyer buddy, my co-author, and I'll post it on Basecamp. The answer on at least the answer he gives me. Yeah, let me just make a note. Will you give me the number again, Dave? It's 1201.
Yeah, it's 1201, section C.
1, right?
1. Yeah, C1.
Thank you.
It says nothing in this section shall affect rights, remedies, limitations, or offenses to copyright infringement, including fair use under this title. So it's the only exception that the subsection lays out, interestingly enough.
Right. So I'm going to get the answer back to you as soon as I can on Basecamp, but it's a great question.
Thank you. Thank you very much. I appreciate that.
Wow, nobody else has questions? Well, that must mean you're expert. So could you just tell us the answers? David.
Okay, so 2 things. First of all, a question about the process. When these guidelines have been put together, have you involved the rights holders in development of the guidelines, or is it the user?
Never. By definition. And it's not users, it's people in a particular profession. Mm-hmm. So it's filmmakers, it's archivists, it's media literacy teachers, it's people who make open courseware, journalists, music librarians. Oh, I forgot to mention the music librarians. Dance archivists. Anyway, people. Yeah. So the goal here is deliberately not to involve the rights holders, because the rights holders are not subject to the same mission that the profession is.
Right.
And,
I know
the goal of the process of deliberation. This is where the facilitators come in. This is the me and Peter and our friends. The goal of the facilitators is basically to split the convenings that deliberate within this profession. They're always done through a membership organization. And the deliberations are always split between what do you need in order to get your work done as the person who needs to employ fair use, and what do you think about the terms that you just established if that stuff is yours? Which usually it is. There are some situations where it isn't, but usually it is people who are users of uncopyrighted material are often producers of copyrighted material as well.
Okay, and then my question is that I can go into a library, pull a book off the shelf, and Xerox the entire book and walk out with it. And there's a notice on the copy machine, but it's up to me to decide. Now, with moving image and audio material, the calculation is extremely different. And have you ever looked at ways in which that moving image audiovisual might be closer to the Xerox machine model, where having an access copy for your research might be of the entire thing might be considered fair use, as it is with the book and the copy machine when it's for your personal reference and research?
I think that argument is validated in the codes. I think that there are yeah, also in other codes, that argument is validated. That it's some of this is conditioned by other laws that actually impinge on fair use. DMCA, prime among them.
Mm-hmm.
And DMCA was designed. You probably know the history of Bruce Lehman, and it was designed deliberately to undercut exceptions, and it was much worse. It was actually much worse when it started out. If anybody had the misfortune to be around when the green paper and the white paper were issued, that was going to turn the entire internet into a publishing realm for 6 entities. That's what they wanted. They wanted to have absolute control and no libraries, no for sale. And to the extent that the DMCA fulfilled some of that, it took in practice, it took away power from fair use. It did. Mm-hmm. And what continues the trend is the production of digital only copies in a purely licensed environment. For instance, as any archivist knows, it's really, really very difficult to collect music that was only produced for iTunes or shown up on iTunes, right?
Yeah.
And if you ever have to collect anything that Amazon owns, you know that they can take it like any private owner, they can take it down anytime they want to. Mm-hmm. So those are all impingements on these rights. What hasn't happened yet, it would be nice to be able to dream that I could live long enough to see this happen, is to have a challenge that is done on constitutional grounds that would win to such laws and to such licensing regimes that says the future public of this country cannot have any access to the digital culture of our time if you do things this way. And that is a form of private censorship with government approval. I mean, I don't think this particular Supreme Court would go for that, but a girl can dream.
Thank you.
But yeah, what I think is difficult to do is for people who are not as expert as you, is to distinguish between what the law permits and what the actual form permits. Many of my wonderful filmmaker friends are constantly telling me, well, fair use, sure, that's okay, but what about music? And I'm like, it applies to music. And they're like, yeah, but what about photography? And I'm like, photography too. Yeah, but what about stuff on the web? Or else they'll tell me, yeah, but everything on the web is free, right? It's not copyrighted. And and really fair use applies to all media in all forms, right? But some economic forms, some forms of distribution, some forms of production make it more difficult, especially for those of us who are interested in preserving and making accessible culture for the future. I mean, many of us are thinking not about in our own lives, but what about the person who comes 40, 50 years from now and wants to know what happened? Anyway.
Thank you.
Other issues?
I'll just note that Karen just put in chat a great suggestion. It looks like she's still there, but she said she had to leave soon. I think it would be good for this committee to pursue would be to find avenues for us to spread the good word about what archives can and can't do to exercise their rights, which is really, that's the focus of a talk Pat and I are actually pitching to AMIA for the upcoming conference for a panel. She suggests maybe create an education forum for AMIA members and beyond about best practices to allow access to moving image collections. Is there a code that you have in your wealth of code library there, Pat, specifically archive do's and don'ts or common activities?
Yeah, and I think if you go back to the slideshow, the biggest ones that are most obviously useful, I think, are the ones about fair use in orphan works for memory institutions, which is all archives. the academic librarians, and all of these deal with access issues, by the way. I think that Karen's idea is so interesting because I think access is such a hot button issue. I think it might be nice just to focus on access. And this was a huge issue for the software people. The big, big issue for software people, and I don't know how big it is in audiovisual generally, is emulation as a service, because one archive has a copy of some rare piece of software and wants to be able to remotely offer it to make it available to another collection, not just to their own patrons. And they actually decided in their deliberations that it was possible under fair use. But I'm super excited that Karen has that idea, and maybe we could follow up with her to see if she has thoughts about guest people for that panel. Or if anybody here does too, that'd be great. Because we'd love to hear from people who are doing creatively employing fair use to provide access and to do the best kinds of preservation.
Hope from the Library of Congress is great. Hope O'Keefe. I think she'd be great. She does come from the Library of Congress point of view in terms of what they can and can't do as a federal institution, but it's, I think she's got to really be great.
In terms of putting out a circular or putting out a publication from the LOC, is that what you mean?
Presenting on a panel.
Presenting on a panel. Yeah, I think that would be actually a really great voice to hear from. I don't know if either of our two, if Greg or David would be willing to subject themselves to that. We can talk about that, I guess, offline. And basically, Pat and I wanted to kick this off with this informational session today, but with the hopes of really finding out from you all what you think is the most valuable avenues and issues to pursue as a group, so that we can start putting together some resources, not just for our group, but to share with the broader community. So,
and if you could do that in 7 minutes, it would be great, because we lose Sandy in 7 minutes.
Right.
Or you could put it in chat, or you could write us, or put it on Basecamp.
Well, one thing that we're looking at is, I'm sure you're aware of the Internet Archive and their controlled digital lending. And given that our research centers are closed currently and will be for a while, and even when they reopen, there'll be people who are uncomfortable traveling. What can we do in terms of making things more accessible using kind of the video equivalent of controlled digital lending in order to provide research access, one-to-one research access, not broadcast.
And this is where actually the Academic Librarians Code and the software code are both very helpful, because they deal with what it would take to let somebody into a digital equivalent of your library. And basically, what they're recommending is have a screen that shows up that says, first of all, say, why are you coming? What do you want? Make sure that they have some scholarly or research reason. And then let them in after they have said, I understand that I'm looking at this for research purposes. And then have make it only available for them then. That was their recommendation for handling remote access. And people who have been doing that have not had problems. Also, one of the things that people have been doing with digital exhibitions is making sure that in the digital exhibition somewhere, or the digital collection, making the digital collections available. These are people who are making digital collections available to the general public, to the world. And what they're doing is putting a little disclaimer that says, if you see anything here that we don't really know in many cases who the owner is here. But if you see something here that you think should not be here, either because you are the owner, or, you know, it was your grandfather or whatever that made this and you don't want it to be here, please let us know and we'll take it down. This is another way of saying, you know, this is what the terms we're putting it up as. The University of Kentucky has a vast collection of tourist photographs of Kentucky's part of Appalachia, the Smoky Mountains. And so I think it's called the Smoky Mountain Postcard Collection. And so they have all those postcards up and you can just look decade after decade of these tourist postcards. And, you know, people who are historians and people who are art historians, all kinds of people want to watch. Well, they have no, you know, they didn't ask anybody's permission to put that up. The University of California, Berkeley put up a bunch of photographs of the university campus that have been donated over the time of the life of the University of California. They're by and large extremely boring, but apparently are interested to architecture students and landscape students and whatnot. And in both cases, the only time they've ever gotten anybody writing them based on this disclaimer was somebody saying, oh, it's so wonderful. My grandpa took that photograph. He's so glad if you put his name on the, you know, identify him, but never have had any problems, at least not yet. And it's been almost a decade.
I think maybe one thing that might be useful to people is giving people guidance on how to approach risk assessment. I think that, you know, we can sort of talk about trying to sort of, you know, calculate in this way of what risk is to your organization, but, you know, and so much of that is so like context specific and situation specific, but just kind of trying to provide folks with resources of just like a framework of how to approach those questions, I think would be like really, really useful, because I think, as you sort of indicated in your presentation, like folks tend to just get stuck on like, well, how do I do this? How do I do this? How do I do this? And they just get overwhelmed and stop.
You know, I feel like that's such a great idea. That is actually, and I feel like the resources are there because that's exactly what the codes do. Because what the codes don't say like, here's the law. What they say is the law is available to you. Oh, tell me this is my friend from GBH. The codes don't say, this is the law, apply it. What they say is, this is the law, and here are common situations you face.
Mm-hmm.
Yeah.
And when you face those common situations, here's how you decide whether you're comfortable or not. Mm-hmm. So that's actually risk assessment. It says, am I doing this? Am I doing that? Am I staying with this? Maybe I should trim this back a little and then I'll be within what the field thinks is safe to do. And the codes all exist not in the field of fair use as a whole, but in the safe harbor area where there's no controversy. So there's plenty of fair use outside the code. But what the codes do is to give you a risk assessment that says, if I'm here and I do this, in this common situation, I can pretty well assume there's a vanishingly small kind of risk. There's never not risk, but the risk is now going to be so small that, you know, it's in an area where clearly it would be much more important to do this based on mission than it would be to not do it based on possibility of harming my institution. Mm-hmm. So that's a really good point, that making clear that giving people some examples of the specific situations, because people always say, well, fair use is context dependent and it's case by case, which is true, but a lot of the cases are exactly the same. Mm-hmm. You know, if you're deciding, you know, can you put this up on Canvas or on electronic reserves for somebody, you're making some of the same calculations on the same stuff all the time.
Right.
I actually have to leave to host another meeting in another app. But feel free to stay on and continue the conversation.